Yes, yes, yes.
Okay, okay, sir. Okay, sir. Shama, yes, over to you.
A very pleasant morning to all intellectuals, honorable guests, and my respected teachers. On behalf of Keli Society's Keli College of Law, Navi Mumbai, I, Shama Musa, welcome you all. I will be hosting today's session along with Professor Muhammad Salim Khan, sir, who will be moderating the event. Our guest speaker for today, Advocate Pravartak Pathak, sir, has joined us. A very warm welcome to you, sir.
Thank you.
Today, sir is along with us to enlighten us on public interest litigation on COVID-19. I would now like to request our principal, sir, to address our guest speaker and our participants. Over to you, sir.
Uh, thank you, Shama. Thank you very much.
Welcome, sir.
Very good morning to one and all. First of all, I would like to take this opportunity to welcome my dearest friend, Advocate Pravartak Pathak, who is doing very well in Bombay High Court, and he has dealt in very important cases. So, on behalf of Keli Society's Keli College of Law, I would like to welcome Advocate Pravartak Pathak, who is an alumnus of DES Law College. Welcome, sir. Welcome on this occasion. And I hope that this session will be very fruitful for all the students, those who are listening to you. And I am also very happy that our management chairman, Dr. Prabhakar Koreji, who is consistently supporting us to conduct webinar series. Then I'm also thankful to Shri Mahantesh Kavadigimat, MLC Government, who is a source of inspiration to all of us, Dr. Mallikarjunaya, who is our mentor, all the students of Keli Law College, all my teachers, and all the participants. Without wasting session to Professor Salim Khan. Salim sir, over to you.
Thank you, sir. I, Professor Muhammad Salim Khan,
Yes, please,
on behalf of Key College, welcome everybody. It's my pleasure today to introduce the speaker of the day. Today, our guest speaker is Advocate Professor Pathak. Has his PLLE from Litigation Society Law College, Pune. Sir has done his with specialization in international law and arbitration from Jaffrey University. Sir is based out in Mumbai and practicing at Bombay High Court 2009. Sir regularly appeared for the India as a counsel. Recently, Sir was awarded this Pravartak for young professionals. Congratulations, sir. On behalf of our college, I congratulate you for the achievement. Known for public interest litigation to the right of the marginalized section of the society as well as environmental litigation. Sir has been elected unanimously as the member of the governing council of the Bar Association of India as representative of state master. Congratulations again. Sir has delivered several seminars and conducted courses at a number of educational institutions concerning environmental law, constitutional law, and international arbitration. It's a pleasure to host you over here, sir. Without wasting any time, our listeners are very eager to listen to you. So I hand over the please continue. Start. Thank you.
Uh, Thank you, Professor Mr. Muhammad Salim Khan, sir. It's my pleasure to present this topic, public interest litigation during COVID-19, before all the students. And before start, I must express my gratitude to my dear friend and Professor Dinkar Gite and all the professors, and especially the Dr. Singh, who consistently followed with me for this successful to make a success of this today's lecture. So let me start my today's presentation on the topic. Today I will speak on public interest litigation during COVID-19. To begin with, I will initially explain that what is the public interest litigation, and then we will just go through that how this law relating to public interest litigation has been evolved. Then we'll go through the Supreme Court guidelines and then the Bombay High Court rules, which was passed in 2010. And then we'll see the how this approach towards public interest litigation has been changed over a period of time. And then we will jump to the public interest litigations filed, especially during this COVID-19 pandemic situation. So let
Sir,
me.
I'm extremely sorry to
Yes.
interrupt you, sir. But sir, again, you have to disable that annotation because you have started again.
So it is done now. Disable attendee. Is it done now?
Yes, sir. I think if you have disabled it, then it is okay, sir.
Yeah, I think I have done.
Okay, sir. Then it's fine.
Yes.
Thank you, sir. Thank you.
Welcome. So the first question is, what is public interest litigation? Is it defined anywhere in the Constitution of India or any statute? Obviously, the answer is no, because Article 366 of the Constitution of India deals with the definitions of certain terminologies which are used in the Constitution of India. This Article 366 does not cover what is the definition of public interest litigation. But we can see that the powers given to the High Court as well as Supreme Court to deal with the fundamental rights as well as the various legal and constitutional issues. The power, so far High Court is concerned, the powers are given under Article 226 of the Constitution, and so far Supreme Court is concerned, the powers are given under Article 32. Now, so far Article 32 is concerned, the Supreme Court is the custodian of fundamental rights which is guaranteed under the Constitution. And so far the powers of the High Courts are concerned, the person can approach for the violation of fundamental rights as well as for the violation of any other legal rights. So who can approach under Article 226 or under Article 32, either to the High Court or Supreme Court? The person needs to have a locus standi. Now, what is locus standi? Locus standi means a right of a person to approach court of law in case of violation of his personal rights. Now, when we are talking and discussing about the public interest litigation, there is obvious thing that there may not be personal right is involved, but the interest of public at large is involved. And therefore, this concept of locus standi, which was very rigid prior to 1976, therefore, there was no concept such as the public interest litigation. And I think that the first case was Mumbai Kamgar Sabha versus Abdul Bhai. In this Mumbai Kamgar Sabha, for the very first time, Justice V.R. Krishna Iyer relaxed the concept of locus standi and allowed the union to approach the Supreme Court for violation of the for blatant violations of the some rights of labor section. And this is how the the sphere of this present public interest litigation was started in the year 1976. Of course, this law relating to public interest litigation has been developed over the time only because of the judicial activism. Since we are the law students, everyone is aware that whenever there is a gap between the available legislation and there is no law as such available, statutory law, at that particular point of time, the Supreme Court played a major role as an activist and tried to fill up the gap which is absent in statutory provision. The best example is Vishakha guidelines. Now, this entire public interest litigation laws developed, it has certain features that when we approach to the court of law, there is always we need to have locus standi. There must be some our personal right has to be infringed, and then we can approach to the court for remedies to remedy our personal rights. But so far public interest litigation is concerned, there is no question of personal right. So therefore, when you approach in a public interest litigation, the nature of the public interest litigation is mostly non-adversarial, and in fact, this is the because of this nature as a non-adversarial litigation, this gives an opportunity to the government to correct what has been whatever injury has been caused to the public at wrong, or whatever corrective measures are required to be taken. Now, there is another aspect so far nature of the public interest litigation is concerned, that in public interest litigation, you cannot knock the door seeking compensation for violation of individual rights. Because if you want compensation, you can definitely file a civil suit by paying the necessary court fees. But so far, public interest litigation are concerned, the merely corrective directions can be given by the High Court or the Supreme Court. When we consider about the regular writ petitions or suit, in normal regular writ petition under Article 226 or 32, it involves a question of fact and the question of law. But when it comes to public interest litigation, it involves wider question of law and the policy as well. Now we'll move to the next aspect, that how this law has been, public interest litigation has been evolved. The first case which is considered as a public interest litigation was the Hussain-era Khatun versus State of Bihar, which the judgment was delivered by Justice P.N. Bhagwati in the year 1979. And this public interest litigation was filed by the advocate on the basis of news report published in Indian Express newspaper, which has highlighted the plight of various more than thousands of prisoners who are lying in a jail as a under trial, and therefore for their personal liberty, this public interest litigation was filed. I think this was the very first public interest litigation which was filed before the Honorable Supreme Court, and the concept of this locus standi was relaxed. And then subsequently, there are more judgments came from the Supreme Court, and especially those judgments are delivered by Justice P.N. Bhagwati. And we must be, as a student of law and as a citizen, we must be thankful to the Supreme Court, and especially Justice V.R. Krishna Iyer as well as Justice P.N. Bhagwati, who considered the plight of those weaker section who cannot approach to the court of law in ordinary situation, and even they cannot afford to approach the court of law. The second case after Hussain-era Khatun was Fertilizer Corporation Kamgar Union. I'm sorry, I think there is a spelling mistake. It's a Fertilizer Corporation Kamgar Union versus Union of India. That judgment came in the year 1981, where the Justice Bhagwati specifically considered that whatever this principal limitation as to approach to the court with respect to locus standi, that has been relaxed. And then subsequently SP Gupta versus Union of India. This SP Gupta versus Union of India is also known as a first judge's case. The petition was filed seeking a direction to reveal certain documents which was exchanged between the then law minister, then Chief Justice of Delhi High Court, and the Chief Justice of India with respect to the appointment of judges. And in that matter, the Justice Bhagwati and the Supreme Court, that bench, considered that whenever there is a public interest is involved, it is bound to the government to disclose this document. Now consider in 2005, since 2005, we have a Right to Information Act. But since it was in 1981, it was very difficult to get all these documents from the government custody, and whenever the public interest litigation, public interest is involved, the Supreme Court directed to give documents and to make it available to the public at large. Then the next case was the Bandhu Mukti Morcha. Again, this Bandhu Mukti Morcha has further opened the doors of the Supreme Court, and PIL, public interest litigations, are permitted even through a representation or writing a letter to the Supreme Court, by considering that being the Supreme Court is the custodian of fundamental rights. The Article 32 has to be read with the preamble of the Constitution as well as the directive principles of state policy. And since then, the doors of the Supreme Court as well as the High Courts are open for violation of fundamental rights as well as the constitutional rights of the litigants, and the law relating to environmental law, violations of human rights, and questions related to administration of justice and various facets of right to life. The Supreme Court started intervening and entertaining the litigations in the interest of public at large. Then, since then, just a second. Since then, the various people started approaching to the Honorable High Court as well as Supreme Court, and then later it was found that in every public interest litigation, there may not be necessarily public interest is involved per se, but there might be a possibility of private interest litigation or political interest litigation or personal interest litigation, which may have filed under the name of public interest litigation. And then since last 2-3 decades, we have started witnessing the misuse of the this concept of public interest litigation. And therefore, the Supreme Court provided some guidelines when the public interest litigation can be entertained, and that guidelines was provided in the year 2010, and the Supreme Court directed that only genuine and bona fide public interest litigation should be encouraged and effectively entertained, and all those litigation PILs with extraneous consideration should be discouraged. And that's why certain guidelines were laid down. You can see those guidelines by visiting this particular judgment of State of Uttaranchal versus Balwant Singh Chaufal and others. Then, based on these guidelines, the Honorable Bombay High Court also notified its public interest litigation rules in the year 2010. Now, these rules are based upon the outcome of various judicial precedents which came from 1980 to 2010, and therefore these rules notified and it was clarified that when the public interest litigation and how the public interest litigation can be entertained, and certain modes are given. The first very mode is the suo motu. High Court or even the Supreme Court can entertain public interest litigation suo motu. Then that suo motu PIL can be entertained only on the basis of order passed by the Honorable Chief Justice of the High Court. Then some High Court judge can, any High Court judge can recommend to the Chief Justice, and accordingly Chief Justice can pass an order to entertain any public interest litigation as a suo motu. Then the third mode is given, that is through if any citizen, law student or lawyer's body, if they makes a representation to the Chief Justice of the Bombay High Court, then that representation or letter can be treated and considered as a public interest litigation. Then High Court can also give a direction in any individual writ petition that if the court realizes that the particular issue involved in any petition involves the questions which is concerning public at large, then High Court can also convert a petition filed in an individual capacity into a public interest litigation. And then this rules provides a complete pro forma under Rule 5 of the this rules. And if anybody wants to file a separate petition as a public interest litigation, then that person is required to comply with this pro forma, and accordingly that petition with the proper pro forma can be entertained by the High Court. Of course, there are some safeguards which are given when you are filing a public interest litigation before High Court. The first and foremost thing is that whatever information you are relying upon in your petition, that source of information has to be disclosed. Then it is mandatory for the petitioner to file an affidavit, as there is no personal gain or private motive or oblique reasons behind filing this public interest litigation. The third aspect is that every person who is filing a public interest litigation, that person has to give an undertaking to the High Court that in case of any cost is imposed on the petitioner is duty bound to pay that cost, and that cost can be imposed only when the court founds that a particular PIL is a frivolous one or with the extraneous consideration. And that power is given to the High Court judges under Rule 11 of this PIL rules of 2010. Then if the public interest litigation is being filed through some body of persons such as NGO or association of persons, then that association must be lawfully registered, and authorization of that association is also one of the necessity in approaching public interest litigation if it is being filed through NGO or any association of persons. Now, consider that it's been 3-4 decades we are getting benefits of this public interest litigation, and the gap between the executive and the legislative machinery, whatever the errors they have committed, the time to time it's the judicial activism who tried to remedize this and tried to fill up this gap as a considering public interest litigation as a non-adversarial litigation. And initially the approach was the Honorable Supreme Court, even as the Honorable High Court, was to encourage a PIL petitioner to come forward and to raise a voice in favor of public at large. And that we can see the order passed in the year 1996 in Indian Council for Enviro Action Legal versus Union of India, where the issue was with respect of some chemical industries in Bichri village of Rajasthan polluted entire soil as well as trees, and it damaged complete agricultural sector in and around that village Bichri in Rajasthan because of sludge coming out of these chemical factories. And ultimately that litigation went on for almost 6 years, and then Honorable Supreme Court directed those companies, offending companies, to pay cost of rupees 50,000 to the petitioners for their efforts, and to encourage voluntary bodies like that petitioner to approach High Court or Supreme Court in a public interest litigation. So that was the scenario in the year 1996. But as of now, we can see that since then, a lot of petitions are coming, and not all the petitions are genuine. And now there is a recent order, that is order dated 16 June of 2020 passed by the Honorable Bombay High Court, where Bombay High Court imposed a cost of rupees 5 lakhs on the petitioner, as the court found that there is no public interest involved in this particular public interest litigation. So this is how the approach of the judiciary in the first 2 decades to encourage the PIL petitioner. Now this approach has been changed, and now the court is trying to discourage all those petitioners who are filing frivolous and false public interest litigation and consuming court's time, which also affects the genuine litigants who are waiting for their turn to get their justice because of pendency of large litigation. Now let us come to the today's topic, that PILs which were filed during COVID-19. Now every one of us aware that the whatever lifestyle we are having prior to March 2020 was completely different, and this pandemic situation brought us in completely unprecedented situation, and our regular life is completely stalled since then, particularly since mid of March 2020. And then subsequently the lockdown was declared by the central government, and almost for now it's been a 3-4 months, most of the things were stalled at least till May, June, and now we are trying to reopen and trying to go back to our normal lifestyle. But still, in this particular situation, what happened that the judicial doors was also closed for initial days, because it's obvious that you cannot go out of your house. Then it was very difficult to approach or go to the court, and since the court was also shut down, and then it was realized that the court cannot closed as it is because of this pandemic situation, and at least urgent matters, wherever there is a necessity, those matters should be entertained. And therefore the Supreme Court as well as the honorable high courts in India started functioning through video conferencing. And since then, immediately the courts opened its door. Again, we have seen the floodgates of public interest litigation. Why floodgates of public interest litigation? There are 2 reasons. Firstly, so far those regular matters are concerned, all those regular matters, the court was not in position to deal with those matters. And there was also a blanket status quo or interim relief in all those pending matters. Wherever there is an ad interim was given, and apart from that, the court directed that not to take any coercive action so far civil matters are concerned. Then the Honorable Supreme Court also extended the law of limitation during this particular time. And the result of this particular various orders passed by the High Court and Supreme Court, which initially dealt with this COVID-19 situation, that resulted into the regular working of all individual lawyers. And therefore, the only option the lawyers had, that is to approach in extremely urgent matters, and the only urgent matters were available is under the public interest litigation. And therefore, we have seen that many frivolous public interest litigation was filed before the High Court as well as the Honorable Supreme Court, but simultaneously many different facets of fundamental rights was also raised before the Honorable Supreme Court and High Court, which has been dealt by the Supreme Court, all the constitutional courts, and some matters are still pending. I'll just, for an example, we'll have a glimpse of some of those litigations which was filed during COVID-19. Before dealing with other litigation, I would like to first deal with the suo motu public interest litigation, which was taken up by the Madras High Court. The Honorable Judge of the Madras High Court watched a TV news on one of the regional news channel, where the one medical practitioner died due to infection of COVID-19. He was a COVID-19 warrior, and when he died, at the time of his burial, the person residing within the vicinity, maybe due to fear, because that time there was no as such awareness that how this disease spread amongst people, and therefore all those residents opposed for the burial, and then that doctor was that body of that deceased doctor was transported to some other place in some other town, and then the burial happened. And during this transfer of that body, even some people attacked on the ambulance. Now, the question which was raised in a suo motu public interest litigation, whether a person having a right to have a decent burial. In fact, that question was also earlier considered by the Honorable Supreme Court. And in such a situation, this particular facet, even after death, was considered by the Madras High Court, and the notices were issued in a suo motu public interest litigation. Then all of us are aware that we have seen the fate of the most marginalized class in this country, that is the labor class. All those migrant laborers immediately wanted to go from their working place to their hometown, because since everything was locked down, there was no source of livelihood and there was no source of income, and they have no option but to anyhow they wanted to reach their hometown so they can survive. Now, in such a situation, initially one public interest litigation was filed before Honorable Supreme Court in initial phase of the lockdown, and in that phase the direction was sought that migrant workers must be returned to their native places by train and without any conditions or without any charges. But that public interest litigation which was filed in the initial stage was dismissed by the Honorable Supreme Court. But subsequently, in the somewhere around in the end of May, when various reports with respect to the fate of migrant laborers, again the Supreme Court took suo motu cognizance of the situations of the migrant laborers. Then the another PIL, public interest litigation, was filed seeking nationalization of all the hospitals in country. Now everyone is aware that the situation is completely unprecedented, but since all the hospitals which are available for the treatment are not only the government hospitals, but there are private hospitals too, and therefore someone approached to the court, no, you please consider and nationalize all the hospitals, so there will be free medical facilities and treatment will be made available to the persons affected due to this COVID-19 virus. But the Supreme Court rejected this public interest litigation, and it is left to decide to the government whether to nationalize or consider the for the hospitals. But subsequently, there was the central government or the state government has given a capping so far medical charges are concerned. Even that, but the public interest litigation was not entertained. Then the public interest litigation was filed for with challenging this Prime Minister COVID Care Fund. That public interest litigation was also rejected by the Supreme Court. Then next PIL which was with respect to payment of wages to migrant workers during COVID-19. Now, in this particular matter, the Solicitor General of India categorically made a statement that specifically this COVID-19 situation, many people are filing the public interest litigations, and these public interest litigation are should be closed down till the country emerges out of this crisis, as the problem which was before the government, whether to deal with all the public interest litigation which is challenging each and every policy of the government, or to concentrate and focus on the remedial aspects of this pandemic situation. Then subsequently, that public interest litigation was also rejected and disposed. Then again, the public interest litigation was filed with respect to with respect to seeking directions to the central government that there should be a proper national relief plan, and further directions were sought that the PM Care funds should be transferred to National Disaster Relief Fund. Now, the question is whether the PIL petitioner can raise the questions which are related to the policy, and therefore the questions which are raising the policy decisions, most of those public interest litigations were not entertained. Then as a students, we are aware that those students who are not in the final year got the benefit of this particular situation, and they got promoted to the next year. But so far the fate of the final year students is concerned, still till date the sword of examination is hanging, because the question is, if they could not if they passed out without any examination, then the stamp of COVID-19 will affect their career, and therefore many student organizations as well as the institutions approached to the High Court as well as the Supreme Court for conducting examination. And subsequently, UGC also given a guidelines to conduct examination, and therefore some class of section also approached to the court that examination should not be conducted. This particular issue is still pending before the High Court as well as Supreme Court. Then the interesting public interest litigation which was filed, that what about the fate of those persons who died during the fight of this COVID-19 situation, more particularly the persons belonging to the medical fraternity and the police authorities. Now, in that matter, the court has sought a response from the state government as well as the central government, that what is the law which deals with this particular, and whether the government is going to incentivize these families, the families of these martyrs who died during the fight with respect to COVID-19. Then we have also seen that many people tried to violate tried to violate the guidelines of this lockdown, and therefore many criminal complaints were lodged. But subsequently, the matters were not properly investigated. That's what alleged by some of the petitioner, and many petitions has been filed with respect to different offences and different events to transfer the investigation from the state government to the central government. Then there is also public interest litigation recently filed before the Delhi High Court, seeking protection of senior citizens who are affected due to COVID-19 situation. As we are aware that in many families, the senior citizens are staying alone, as their children are either not residing with them, or because of their job or their business, they are staying out of station or out of country, and therefore the fate of the senior citizen is also at stake, and the direction was sought to take remedial measures as to protection of senior citizens. Then in one of the important case, the Rajasthan High Court warned the state government as well as the central government to give maximum benefits all the policy schemes, all which are specially released by the or declared by the central government and the state government for the weaker section of the society, as even the schemes are declared because of the procedural hurdles. Some benefits could not be reached to the section of people who deserves it, and therefore Rajasthan High Court warned that Food Corporation of India that you please look into it, otherwise we'll have to entertain. Then the public interest litigation was also filed and directions was given with respect to the adequate facilities to homeless persons with mental illness to deal with this COVID-19 situation. Then recently, one of public interest litigation that was filed somewhere in June with respect to the police brutality. As we have seen that those people who were required or forced to get out of their home for some reason, their personal reason, some of them might get gifted with the police lathis, and therefore these police brutalities are also questioned in this public interest litigation. Then the questions with respect to jail inmates and prison facilities during this COVID-19 was also raised, and the Honorable High Court as well as Supreme Court given certain guidelines, and those under trials or some of the persons having a very behind the jail because of some small offenses were asked to release on parole. Then the public interest litigation with respect to the standard operating process of functioning of the court was also challenged, obviously, which was not entertained by the concerned High Court as well as Supreme Court. Then in one of the public interest litigation, the Bombay High Court has realized that there are some problems in implementing the MCR guidelines, and therefore the Chief Justice warned to the government that the court himself give the surprise visit to the quarantine centers, and if any illegalities or irregularities found, the court may constrain to take necessary action. So these are the various public interest litigation which was filed during this COVID-19 situation, touching to the various aspects of our life. And if we need to categorize, we can categorize those public interest litigation mostly was either related to the public health, for which the Supreme Court and the High Court taken a very serious cognizance. Then the public interest litigation which are related to the weaker section of the society. In those matters also, the all the constitutional courts taken a very serious cognizance. But the public interest litigations raising questions as to the policy decisions of the government, obviously the Supreme Court refused to entertain those public interest litigation, but simultaneously warned that you make it sure that the benefits of this policy should reach to the all the beneficiaries to whom all these policies are entertained. Otherwise, the court will take serious cognizance. In my personal opinion, when I look at this public interest litigation, especially during this COVID-19 period, what I feel that there is a huge amount of misuse of public interest litigation in this particular situation. And because of this misuse of public interest litigation, those persons who are filing genuine petitions, genuine public interest litigations are also affected, because it is obvious if 10 petitions are coming which are frivolous and the one petition is genuine, then it is obvious that court may get sway away, or it affects the outcome of the genuine petition. Then secondly, what I realized in this particular situation, since the court is imposing exemplary costs on the PIL petitioners, because of this approach of imposing exemplary costs, also imposing restrictions on genuine petitioners, because the many genuine PIL petitioners are the activists who are really motivated with the sense of giving benefits to the society, and many of them are not having good larger or greater income, and therefore in case the cost imposed, then they are not in position that they will be able to pay that cost. And it is very relative. Sometimes the court may find any PIL as a very genuine, or sometimes court may find that the PIL is a frivolous one, because many aspects are involved. But so far petitioner is concerned, for every petitioner, he thinks whatever cause or question he is raising is a genuine, and it is in public interest, and therefore this aspect of exemplary cost is seriously creating prejudice to the PIL petitioner from approaching to the Honorable High Court or Supreme Court. Then there are what we have seen, that different facets of fundamental rights was also tried to raised by various petitioners. Interestingly, in PIL filed in the Supreme Court, the petitioner raised a question that he is entitled for right to entertainment, and since due to COVID-19 situation, income is substantially down, he cannot afford to pay charges of various live streaming or entertainment web applications such as Netflix or Prime Video, etc. And then he sought a direction that all these entertainment industries be directed to telecast their content free of cost. Obviously, that public interest litigation was disposed, but interestingly, he tried to raise the question of fundamental right to have an entertainment. Then right to drink liquor, that question was also raised before the Kerala High Court, seeking that due to COVID-19 and lockdown, the people are not allowed to get out from their home, and the home delivery of the liquor be allowed in state of Kerala. Obviously, that petition got dismissed again with an exemplary cost. So this is how people try to get more creative about their rights and entitlement, and they approach. But ultimately, as a citizen of India, we have to be very conscious that what right we are claiming, because ultimately, if we are raising a frivolous rights or frivolous litigation, it affects those who are genuinely approaching to the court of law and waiting for justice. I must take opportunity that everyone heard me very peacefully, and all of you given me this opportunity to express my views. If there is any questions, I am open to question and answer session.
Thank you, sir. Thanks a lot for that great words. Sir, with your due permission, may I start the question answers?
Yes, sure.
Yeah. So the first question is from Dr. Pradeep Desai. He says that, can public interest litigation be filed against political parties to restrain them from taking their MLAs to the hostel or resorts, as it is happening in Rajasthan?
It is very interesting question that whether the question is whether the public interest litigations are filed against the political party.
Yeah.
The public interest litigation can be filed against the state even and the institutions who are discharging functions of the state. Now, so far, the questions relating to transporting certain MLAs from one place to other place, it is the question and aspect of the internal aspect of the political party, and there is no as such public interest at large is involved, and therefore, in my primary opinion, public interest litigation not be filed against this particular aspect. But if someone wants to try, then definitely can try about this aspect as well.
Thank you, sir. Thanks a lot. Sir, the next question is from Manish Das. He asked that if public interest litigation can be filed for violation of lockdown during the pandemic.
For violation of this lockdown guidelines, there is a separate procedure or separate provisions are given itself in the guideline, and for this there is no need to file a public interest litigation, but you can approach to the concerned police authorities and point out that the guidelines, lockdown guidelines has been violated, and then the authority can take action. If authority fails to take any action against those persons who violated the guideline, then you can approach in public interest litigation seeking a direction that the authority may be directed to take appropriate action.
Thank you, sir. So the next question is from Mr. Prakash Kumar. He asks that in COVID scenario, theft and black marketing are increased. Can we file a public interest litigation in such situation?
Sorry, can you repeat this question? Theft and?
Yes, sir. He says that in the COVID scenario, theft and black marketing has increased. Can we file a public interest litigation in such a situation?
I don't think that public interest litigation can be the solution for the black marketing. Ultimately, in public interest litigation, what you can challenge is the guidelines of the government. What you can do is to challenge the guidelines because of which the result is black marketing is there. And of course, this black marketing is an offense, and those persons who are doing the black marketing, you can lodge a complaint against them. PIL is not the solution.
Thank you, sir. So the next question is from Hina Ashwinaru Vora. She says that the Solicitor General of India said that one should focus on the pandemic remedies. But at the other end, the government recently focused on the education, that is the new education policy, and introducing new one. What is your say on this?
See, government does not function only through one particular body. There are several ministries, several officers. Through all these officers, the government is functioning, and I don't think that there is any difficulty in introducing any national education policy. Now the question is that whether how we can implement that policy, and it's a duty and responsibility of government to come up with the policies and to implement those policies. So there is nothing wrong if government is coming with the policies. The problem is that if someone is filing the frivolous litigation consistently before the High Court and Supreme Court, because ultimately those officers concerned related to those ministries, they need to invest their substantial energy on this litigation instead of thinking or spending their time to find out the solution on the problems which is created because of this unprecedented situation.
Thank you, sir. So the next question is from Shahriar Kareem. He says that in case of government jobs, why there was no work from home facility? He's quoting to the government of West Bengal over here. Is there any PIL filed against this?
Honestly, I'm personally not aware whether the public interest litigation has been filed with respect to the government employees, and those government employees be allowed from work from home. But I think some departments allowed their employed work from home as of now, because as per directions, many offices are working with a limited strength. And even for the High Court, I know that even some of the officers are working from home, and in fact, those people are working 24/7. As of now, I'm not aware whether this ADPL is there.
Sir, the next question is from Ratan Prasad. He says certain PILs are filed to get personal gains. So in such a situation, how we are supposed to deal with it?
See, it's the High Court and the Supreme Court guidelines are specifically given on this particular aspect, because now, apart from public interest litigation, there are two kinds of PIs has been filed. First one is related to the political interest litigation, then the personal interest litigation. And so these are kind of PIs which are filed, and therefore the guidelines are given, and the clause with respect to the imposition of exemplary cost has been given in the rules and as well as the guidelines of the Supreme Court. But I think that it is very difficult to decide or to judge whether any particular PIL is filed for only with an oblique motive or frivolous or with a frivolous intention. Let the court decide it. What can be done is that there is a possibility that public interest litigation before going for full-fledged hearing, because there are 3 stages in a high court: pre-admission, admission, and the final hearing. Now, even before the pre-admission stage, before the division bench, matter can be heard and the primary views can be obtained that the intentions of the this particular petition and the questions which are raised really involves public interest or not. So this is how it can be filtered.
Thank you, sir. Sir, the next question is from Anup Kumar. He says that looking into the spate of PILs filed in the High Courts and the Supreme Court, would you suggest that the Supreme Court and the High Court should create a special bench exclusively for PIL?
I think there are benches, even the present Chief Justice of the Bombay High Court exclusively dealing with the public interest litigation. And it's been 4 decades. I think every High Court in India as well as the Supreme Court always given a priority whenever there is a public interest is involved. That's why I pointed out, when there are frivolous public interest litigation or whenever there is a misuse of public interest litigation, all those genuine petitioners, including public interest litigation PIL petitioners as well as the individual petitioners, all their rights is also get affected because of this frivolous PILs. As always, it is a policy of the judiciary to give a priority whenever there is a larger public interest is involved.
Thank you, sir. So the next question is from Kunal Jadhav. Kunal says, there are various High Court and Supreme Court directions given to the state saying that the PPE kits should not be charged to the patients, but still certain private hospitals and others are charging it on the patients. Okay, do you feel that it should be enforceable as a part of directive principles of state policy?
See, there are 2 aspects. We are considered as a welfare state. But when we think about as a welfare state, we cannot, as a state, cannot impose so far economic restrictions are concerned. If someone is misusing whatever the guidelines and policies, because as of now, the recent guidelines, as per recent guidelines, so far 80% beds of the hospitals are concerned. All those 80% beds are required to charge as per the capping given by the government, and so far 20% beds are concerned. The hospitals are free to charge as per their regular medical fees. But I think capping is sufficient, but giving completely freebies to all the citizens is not advisable.
Thank you, sir. Thanks a lot. Sir, some more questions with your permission, sir.
Yes.
Thank you, sir. Sir, next question is from Arif Sheikh. Arif says, the 38th Chief Justice of India, Shri S.H. Kapadia, has stated that substantial fines should be imposed on the litigations filing frivolous PILs. And sir, my question is that how court would recognize that whether the PIL file is a genuine one or a frivolous one?
See, that is a very basic fundamental question to decide how one can immediately judge at the threshold that whether PIL is a frivolous one with oblique motive or genuine one. That can be considered only when the matter comes before the appropriate judicial officer and when they take the prima facie views and approaches of the concerned respondents, that is government authorities. So that's why I have suggested that there is a possibility of filter taking primary views on this PIL, and if it is found that there is a blur line between whether a particular litigation is a genuine one or the frivolous one, then it is left to the court to decide. But I think that it is my personal opinion that at the threshold, claiming threshold, pointing out that if there is a frivolous litigation, we will impose exemplary cost is also affect the mindset of genuine litigants as well.
Thank you, sir. Sir, next question is from Dr. D.R. Kshirsagar. He says that writ petition, public interest litigation, jurisdiction under Article 32 and 226 of the Constitution. What about Article 32, Part 3? Provisions, do you think that in the present situation it can be invoked?
If you wish to invoke it, you can approach to the Supreme Court. Let the Supreme Court decide.
Thanks a lot, sir. So the next question is from Dr. Sunil George. Dr. George asks, can public interest litigation be filed against elected legislatures who get elected on the tickets of the party and defect to the political parties of petty political gains?
I think this particular issue has been raised by several persons time to time, but ultimately there is a law which is related to defection. And if someone is defected, yes, the court can take action. A political party can take action against that person. But ultimately, to get rid of that defection, there is a statutory provision. And only you can approach to the court that the statutory provisions are violated. Your right to vote is not a fundamental right, but it is a legal right. And therefore, only when there is a statutory violation, you can approach to the court.
Thank you, sir. Sir, the next question is from Pramani Barua. She says that, can public interest litigation be filed against those political agencies who try to spread negative thoughts against the ruling party who is trying the best to fight the pandemic, as those negative thoughts and words can affect the mental strength and capacity to stay positive in this tough time?
I think it's you who is thinking that they are spreading negative thought. Well, ultimately, the problem is, rather than problem, I must say that in every citizen of India is a fundamental right to have a freedom of expression. If someone is spreading negative thought, you can counter it by spreading a positive thought. PIL is not the solution.
Thank you, sir. Sir, next question is from Dr. Dharmesh Mehta. Mehta sir asks, can PIL be withdrawn by the petitioner before the final disposal?
I think before final hearing, when there are the counter affidavits has been filed, various interventions came in any public interest litigation, then it's not easy to withdraw public interest litigation. Now, then that is up to the court whether to permit or not to permit. Only in case of genuine reasons, court may allow to withdraw it.
Thank you, sir. Sir, the next question is, the court can easily function in online mode to clear the backlogs of the courts in US and UK and other countries. So, what is your opinion regarding this? To continue the online courts after the pandemic?
I wish that all the courts should function online. That is one aspect. But I must say, as a lawyer, that the physical hearing cannot be replaced with the online hearings, because the way you interact with your colleagues, the advocate appearing for the other side, you can exactly see the expressions, and then you can decide how you are going to put your argument. So that facility, and I would say that pleasure, is not available in online hearing. But yes, in a difficult time, we must shift to the online hearing. The problem in our country is that there is a class of lawyers who cannot afford who cannot afford to have all the infrastructure. See, even if I wish to argue through video conferencing before the court, I must have a very good bandwidth. And till date, even I am residing in a good locality, even I subscribe for 100 MB per second bandwidth, still I am facing that difficulty. So there are a lot of issues, difficulties. If those infrastructural issues can be resolved, yes, video conferencing can be the solution, but that should be in an exceptional case, not in a regular one.
Thank you, sir. Sir, another question from Manisha Das. She says that, can PIL be filed against a minister?
See, normally the public interest litigations are filed against the state government. State government, though there is a ministry, the ministry can be pleaded as a party through the secretary or the director of any particular department. You cannot file a public interest litigation simply sitter as by naming the concerned minister. Yes, but when there is a personal allegation against any particular person, be it a minister or any ordinary citizen of India, that person can be pleaded as a necessary party since there are personal allegations.
Thank you, sir. Thanks a lot, sir. A last question. This is from our college students, Vishal Sharma, 5 years law course. He says that, is PIL the same as a writ petition? What law governs PIL?
Sorry, can you repeat your question?
Yes, sir, please. He says that, is PIL the same as writ petition? What law governs PIL?
So far public interest litigation is concerned, I think that since from inception I have pointed out that how this law relating to public interest litigation has been evolved. In a regular writ petition, there is a limitation to approach to the court. That limitation is with respect to the locus standi, and so far public interest litigation is concerned, that concept of locus standi has been relaxed by various judgments and the law created by various precedents. So all these precedents are as a law which governing the public interest litigation, and of course there are rules of the Bombay High Court, rules of 2010, as well as the Supreme Court guidelines. So this is the legal structure to entertain the public interest litigations.
Thank you, sir. Thanks a lot for answering that marathon questions. With that, I conclude the question answer session, and I hand over the mic to our student, Shama. Over to you.
Thank you so much.
Thanks, sir. Thanks, sir.
Thank you, Salim sir. It gives me an immense pleasure to propose a vote of thanks on behalf of this esteemed institution, Kelly Society's Kelly Law College, for this event. I would like to express my sincere gratitude and heartfelt thanks to Mr. Advocate Pravartak Pathak sir, who, despite from his busy schedule, has found time to honor this session with his inspirational thoughts and educating all of us with such an informative session. Thank you so much, sir, for making excellent presentation and making this webinar a grand success. We all gained a lot from you today, sir. I would also take this privilege to thank the respected members of KLE management, Dr. Prabhakar Kore, sir, Chairman of KLE Society, Mr. Mahantesh Kavadgimat, sir, Governing Body Chairman, KLE College of Law, MLC, and Chief with Government of Karnataka. Dr. Mallika Arjunaya, sir, Principal KLE Law College, Bangalore, and Director KLE Law Academy, Bangalore. And our respected Principal, sir, Professor Dinkar Gittis, sir, for their blessings and guidance. I am also grateful to our teachers, Dr. Amrita Singh, ma'am, Professor Pooja ma'am, Professor Salim Khan, sir, and Professor Shividya ma'am for their valuable contribution and encouragement in all our efforts. I'm also thankful to my fellow students convener Atul and Roshan, and for the whole team who for their contribution, for their support for the webinar. And last but not the least, I would like to thank all our dear participants who has joined us in huge numbers and making this webinar again a grand success. Once again, I thank one and all present here. Thank you very much, sir.
Thank you, Shama. With this, we conclude the session today. I request all the participants to please fill the feedback form. The feedback forms have been posted in the chat box of the Zoom as well as the YouTube channel. Thanks a lot, sir. Thank you, sir.
Thank you for inviting me and giving me this opportunity to express my views at this presentation. Thank you.
Pleasure is ours, sir. Thank you. Thanks a lot, sir.